I'm the CEO of China Biomedical and Technology Education Association, which I founded 20 years ago. Welcome to World IPF 2025. Our panel is Patenting Biotech and Pharmaceutical Invention, Navigating the Complexity. In today's rapidly advanced technology landscape, biotech and pharmaceutical stands at the forefront innovation. As researchers and scientists uncover groundbreaking discovery, and the importance of securing intellectual property rights for this invention become paramount. However, navigating the complexity of patenting in this highly specialized domain research requires a unique set of challenges. So for understanding the intricacies of patent law to ensure compliance with the regulatory framework, stakeholders must definitely maneuver through a maze of legal, ethical, and scientific considerations. So this journey is essentially not only to protect the fruits of science labor, but also to foster an environment that encourages continued innovation and development. Join us as we delve into the multifaceted world of patented biotechnology and pharmaceutical inventions and explore the strategy to overcome the hurdle along the long way. Today we have 6 esteemed experts in this panel. It's Mr. Michael Fuller from Connaught Martin, USA, and Dr. Manny Roy from Coolidge LLP, USA, and Mr. Divya Shekar from Dependence and Dependence, India, Mr. Avi Garg from Les Orbis, India, and Mrs. Sumanapa Prasad from LS Devi Corporate, India, and also Mr. Vadim Kuala from NCO Association of Pharmaceutical Company. And our panelists will introduce themselves first, and they will tell you their expertise, preponderance, and records, so you can observe their expertise, and after when we open the Q&A, it will be very easy to learn from them and ask the right question to benefit yourself for this conference. And today we will also penetrating the issues such as jurisdiction-specific complexities, subject matter eligibility, and patentability criteria, and enablement requirements, written description, regulatory and policy interference, and also AI impacts on this innovation and other IPR set regarding marketing, legal aspects, law enforcement practice, and also some court cases sharing.
Very good afternoon to all of you. I'm Divya Shekar, and I head the Pharma, Chemical, and Biotech division for Depending. I also head the Bangalore office, and in my capacity as the practice head, I have had the privilege of representing a lot of MNCs, innovators, and previously as part of the strategic objectives of being the practice head, I have also initiated the process of creating IP awareness for startups, innovators, educational institutions, and also MSMEs down south, and that has been quite an enriching experience in the last 5 years. And I really look forward to exploring today's topic with my fellow panelists, and hope to make this an engaging and interactive session. Thank you.
After we have learned the expertise of our esteemed panelists, now we will start today's discussion on patenting biotechnology and pharmaceuticals. First, we would like to discuss the complexity on subject matter eligibility and patentability criteria. As the natural product has faced a heightened scrutiny, master patent must be transformed beyond natural process. Diagnostic method is particularly challenged after the post-Mayo era. May our panelists share their situation in their own country, please.
Thank you. So, I would like to discuss the patent eligibility issues, but before that, I'll focus on the India aspects of it, and also set the context for us to discuss this in greater depth. To bring a perspective with numbers, there have been about 315 315,000 applications, patent applications filed in the life tech space, life science, chemical, pharma, food and biotech space with the patent office in the last 5 years. And what chunk of this actually constitutes, 315,000 overall patent applications filed in the last 5 years, and what chunk of this actually constitutes your life science inventions? It's just 75,000 in the last 5 years, and that's a consolidated number of all your biotech, pharma, chemical, food, and bioscience related inventions. Now that just constitutes about 23% of your complete, consolidated patent filing in India. Now, why are these numbers so low? I mean, they definitely do not do justice to the kind of innovation that's happening in India, but the numbers are quite low, the patent filing numbers. One of the main reasons for it is the patent eligibility standards being set at a very high bar with the Indian patent, with respect to the Indian patent law. Well, one might ask why. Why is it the case? And just to set the perspective for this, and we just have to look at the pre-TRIPS era and the current standard with respect to India being the generic hub. So India being the pharmacy of the world and valued at a market of about $50 million today. Definitely there are economic, regional, ethical and public health issues, perspectives in place, but the main focus has been to enable the thriving of this pharma and generic industry that existed in the Indian subcontinent. And therefore, when India transitioned to the post-TRIPS era in 2005, they ensured that there are proper checks and balances in place with respect to various different kind of non-patentability provisions that were incorporated into the law to ensure that the proper checks and balances were put in place. So today, well, if you look at the Indian patent law, there is section 3 that stipulates or outlines what inventions are deemed non-patentable, and you have about 14 different provisions under which an invention can be deemed non-patentable. But out of the 14 provisions, there are at least 8 provisions which are directly pertinent to life science-based inventions. It could be food, biotech, chemical, pharma. So the filter for patent eligibility criteria in India is set at a very high bar. And of course, I will let my fellow panelists to talk on the various singular provisions that apply and how they apply. But I'll just give an example of section 3C, which prohibits discoveries or discovery of any living or non-living substances occurring in nature. Well, this would apply for your isolated products. It could be plant extracts, it could be isolated microorganisms, it could be just a genetic sequence occurring in nature. So all of these inventions will attract the provisions of section 3C and will be deemed as being a mere discovery. And I would like to just also discuss an important case, a landmark case that came about last year, where a patent application directed to a monoclonal antibody was refused under section 3, and it was being deemed as a discovery of a living substance, a non-living substance. And why? Because it was deemed that the antigen occurs naturally in the human body, and therefore it was speculated that an antibody to a naturally occurring antigen could be present in the human body. And to add to that, the sequence listing had mentioned that this sequence has been obtained from a Homo sapien, and therefore this monoclonal antibody, which was a cancer drug, was objected as being a discovery of a non-living substance occurring in nature. Well, we did have the Madras High Court come to our rescue in this matter, and they clarified that, well, it is a monoclonal antibody, but it has been artificially synthesized. It's not naturally occurring, and it definitely is involving a human intervention. And just the very fact that the sequence is obtained from a Homo sapien cannot, make it naturally, a discovery of a naturally occurring substance in nature. So that is the level of scrutiny, and that's the level of rigidity with which the Indian Patent Office examines inventions with respect to the various filter, the eligibility criteria that has to be scrutinized. And hopefully thankfully we are getting a lot of interesting decisions from the higher courts, which are clarifying our interpretation of the various provisions. But yes, so I'll pass it on to Avi and Suman to also discuss on the other various provisions which will be scrutinized with respect to patent eligible subject matter.
Sorry, can I just ask one quick question on the first presentation about the monoclonal antibody case, which is interesting. Is the reason for the allowability because there was a sequence difference, there was some structural difference with the monoclonal antibody as opposed to the endogenous antibody, or was it merely the fact that there was human intervention going on, and they could be identical, but since there's human intervention, it's allowable? And I'd be great if we reminded of the position in the US about that as well, actually.
Well, the whole underlying reasoning that the examiner gave for refusing the application on the monoclonal antibody, this is GenMab versus Controller of Patents, was that one, the antigen, which was CD38 antigen, is a naturally occurring antigen in the human body. And he was making the assumption that, well, if there is an antigen, there would be, of course, a naturally occurring antibody as well. That was a very speculative argument. And he did not have a prior art document, he did not have any literature to support the fact that, yes, there is also a naturally occurring antibody. So there was no evidence to support that, but that was just an allegation. And in order to supplement his allegation, he just identified that, well, the sequence listing shows that this antibody has been obtained from Homo sapiens, but that is just a part of your sequence listing criteria that you have to, you have to identify the origin of the antibody. So the court identified that, one, this is not a naturally occurring antibody because you have not you have not supplemented your argument with a document or a sequence that reads upon the sequence of the monoclonal antibody that the patentee has claimed. One. Two, just the fact that the antibody is obtained from a Homo sapien is not sufficient enough to allege that it is a naturally occurring substance. And three, also that this has been artificially synthesized. Now, if you look at the heavy chain region and the light chain region, and also the various other fragments that made up the monoclonal antibody of the invention, it was definitely very different from possibly the naturally occurring repository of the of an antibody or monoclonal antibody that occurs in a human body. When that was also a speculation, by the way. So that's exactly how essentially this 3C objection was finally circumvented, and I think it's quite an interesting decision to read.
Yeah, thank you. So there wasn't really a kind of conflict piece of prior art.
Yes. So there was no. It was not evidenced with prior art, but it was just a speculative argument that the controller was. Yeah.